A decision just came out of the United States Supreme Court that almost no one in the media is talking about, yet it has the potential to affect millions of everyday drivers who legally own firearms. The ruling was unanimous. Every single justice agreed. No split opinions, no ideological divide. And what they said could change how traffic stops involving firearms are handled across the country. If you legally carry a firearm and you also drive a vehicle, what I'm about to explain could one day determine whether a routine stop ends with a warning or with you standing on the side of the road in handcuffs, facing charges you never saw coming. So let's walk through this carefully in plain English. The case at the center of this storm is called Torres v. Madrid. On the surface, the name might not mean much to you, but the constitutional principles tied to it absolutely should. This case forced the court to address a tension that had been quietly building in lower courts for years. That tension involved the parts of the Constitution that every American has heard of, but not everyone fully understands together: the Second Amendment and the Fourth Amendment. One protects your right to keep and bear arms. The other protects you against unreasonable searches and seizures. For a long time, most people assumed those rights operated independently. You could own a firearm legally, and you could expect that police needed probable cause or a warrant before searching your vehicle. Simple enough. But some lower courts had begun adopting a dangerous line of reasoning. They were essentially saying that the mere presence of a firearm inside a vehicle automatically elevated a traffic stop into something more suspicious. In other words, even if the firearm was completely legal, officers could treat its presence as justification to conduct a warrantless search of the entire vehicle. Think about what that implies. If exercising your Second Amendment right automatically weakens your Fourth Amendment protection, then you are being forced to trade one constitutional right for another. That is a constitutional collision course. The situation that brought this issue forward began during what should have been a routine traffic stop in New Mexico. The driver was pulled over. No violent crime, no dramatic chase, just a stop. The officer approached and, as officers often do, asked the driver to step out of the vehicle. That request alone is generally permitted for officer safety. Then came the question that millions of gun owners have heard before: are there any weapons in the vehicle? The driver answered honestly. He stated that there was a firearm secured inside the glove compartment and that he possessed a valid concealed carry permit. He was calm. He was cooperative. He was following the law as he understood it. What happened next is where everything changed. The officer proceeded to conduct a full search of the vehicle, not just securing the firearm, not just visually confirming its presence, a complete search of the car's interior compartments. There was no warrant. There was no additional evidence of criminal activity. The justification offered later was officer safety combined with the fact that a firearm was present. During that search, the officer discovered ammunition that allegedly violated a minor local ordinance. The driver was arrested. The lower court sided with the officer. They reasoned that the presence of a firearm, even if legally possessed, created enough safety concern to justify a broader search of the vehicle under what is often referred to as the automobile exception. Now let's pause here and unpack that doctrine. The automobile exception is a long-standing legal principle developed by courts over decades. It allows law enforcement to search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. The logic is that vehicles are mobile. Evidence could disappear while officers wait for a warrant. But there's a key word there: probable cause. Probable cause is not a vague suspicion. It is not a feeling. It is not a hypothetical scenario. It requires specific, articulable facts that would lead a reasonable person to believe a crime is occurring, or that evidence of a crime is present. Owning a firearm legally is not a crime. That simple truth became the heart of the issue before the Supreme Court. When the case reached Washington, the justices had to answer a direct constitutional question: can the lawful presence of a firearm by itself create probable cause that justifies a warrantless search of a vehicle? Their answer was clear. No. In a unanimous opinion, the court rejected the idea that legal gun ownership is inherently suspicious. They stated that exercising a constitutional right cannot be treated as evidence of criminal activity. If it were, then any constitutional right could be weakened simply by labeling it a safety concern. The court emphasized that the Second Amendment does not erase the Fourth Amendment. Both protections exist simultaneously. Neither cancels out the other. That conclusion sends a powerful message. Law enforcement officers can absolutely take reasonable steps to protect their safety. During a traffic stop, they can ask a driver to step out of the vehicle. They can temporarily secure a weapon if there is a specific, articulable safety concern. But what they cannot do is automatically escalate the encounter into a full evidentiary search. Simply because a firearm is present. This distinction matters more than most people realize. Imagine the scenarios. In the first, an officer approaches a vehicle and smells marijuana in a jurisdiction where it remains illegal. That odor may provide probable cause because it is sensory evidence tied to criminal conduct. In the second scenario, an officer learns that a driver has a lawfully owned handgun secured in a case. No erratic behavior, no conflicting statements, no evidence of another offense. Under the Supreme Court's reasoning, that fact alone does not create probable cause. The difference is crucial. The court also clarified that additional factors can still change the equation. If the driver is a prohibited person known to law enforcement, meaning someone legally barred from possessing firearms due to a felony conviction or restraining order, that changes the legal landscape. If the firearm is being carried in violation of state law, such as lacking required permits in a restricted jurisdiction, that also changes things. While legality is the dividing line, a lawful act cannot be redefined as suspicious merely because it involves a firearm. This ruling has broader implications than just one traffic stop. For years, some departments train officers that a firearm in a vehicle automatically heighten the situation. Officers were taught that such circumstances justify deeper investigation. Those training materials may now require revision because the Supreme Court's message was unmistakable. Constitutional rights cannot be converted into triggers for suspicion for everyday gun owners. This decision provides stronger ground to stand on. It means that honesty about lawful firearm possession should not open the door to a fishing expedition. It reinforces that cooperation does not mean surrendering all constitutional protections. But it is equally important to understand what the ruling does not do. It does not prevent officers from taking reasonable safety precautions. It does not eliminate the automobile exception. It does not create immunity from lawful searches based on real probable cause. And it does not override complex state-specific gun regulations. Traffic stops remain dynamic encounters. Officers still evaluate behavior, environment, and context. Nervousness alone may not be enough for probable cause, but extreme evasiveness combined with other indicators could contribute to reasonable suspicion. Visible contraband in plain view remains searchable. False statements can escalate matters quickly. So what does this mean in practical terms? If you are pulled over and you are lawfully carrying a firearm in your vehicle, your first priority should be safety and clarity. Keep your hands visible. Do not reach toward compartments where the firearm is located unless instructed. If your state requires disclosure, calmly inform the officer that you are legally armed in state where the firearm is located. If asked for consent to search, understand that consent is voluntary. You have the right to decline. A simple, respectful statement such as, "I do not consent to any searches," preserves your position without escalating the encounter. If a search proceeds despite your refusal, do not physically resist. Resistance can create additional charges. Instead, clearly state that you are not consenting and allow the legal system to address the issue later. Through counsel, documentation becomes critical. Badge numbers, patrol car numbers, the sequence of events, details fade quickly under stress, so recording your recollection as soon as possible can matter. Another key takeaway is that this decision may influence future litigation beyond firearms, where the court reinforces that lawful conduct cannot automatically generate suspicion. That principle can ripple outward into other areas of constitutional law. Unanimous decisions from the Supreme Court carry particular weight. They signal institutional agreement across ideological lines. When all 9 justices converge on a constitutional interpretation, lower courts tend to pay close attention. That does not mean every encounter will unfold perfectly. Real-world policing involves split-second decisions. Misunderstandings can still occur. Officers may not immediately be aware of the nuances of recent rulings. Some jurisdictions may test the boundaries before appellate courts reinforce compliance. But precedent matters, and this precedent strengthens the idea that rights do not compete with one another. The broader lesson here is about awareness, many gun owners focus heavily on the mechanics of firearms training, storage, permits, yet give less attention to the procedural rules governing police encounters. Understanding those rules can be just as important as understanding ballistics. The Constitution is not self-enforcing. It requires courts to interpret it and citizens to understand it. Decisions like this one illustrate how delicate the balance is between safety concerns and civil liberties. It is also a reminder that small local ordinances can have outsized consequences. The driver at the center of this dispute did not set out to challenge constitutional doctrine. He encountered a minor regulatory issue that spiraled into a test of national significance. That is often how landmark cases begin: a routine stop, a routine question, an ordinary citizen, and then a legal theory that, if left unchallenged, could quietly erode foundational protections. The Supreme Court drew a line. They reaffirmed that exercising the constitutional right cannot be transformed into evidence of wrongdoing. They confirmed that the presence of a legal firearm does not dissolve the Fourth Amendment at the roadside. For those who value both gun rights and privacy rights, that alignment is significant. It clarifies that supporting one constitutional protection does not require sacrificing another. Still, knowledge alone is not a shield. Conduct matters. Tone matters. Compliance with lawful commands matters. Courts evaluate totality of circumstances, not isolated sound bites. The safest course during any traffic stop is calm professionalism. Keep movements slow and deliberate. Avoid sudden gestures. Communicate clearly. Do not argue constitutional law on the shoulder of a highway. Courts exist for that purpose. If you ever believe your rights were violated, consult a qualified attorney familiar with constitutional criminal procedure in your state. Legal standards can vary based on jurisdiction, and procedural rules evolve over time. What makes this ruling stand out is not just its legal conclusion, but its clarity. In a time when many decisions are sharply divided, unanimity signals that certain principles remain deeply rooted. The Second Amendment protects lawful firearm possession. The Fourth Amendment protects against unreasonable searches. Neither right nullifies the other. That is the core message, and while this decision may not generate dramatic headlines, its impact will likely unfold quietly across thousands of future traffic stops, motions to suppress, and appellate reviews. In the end, constitutional law is not about dramatic courtroom speeches. It is about the ordinary moments: red and blue lights in a rearview mirror, a question through a partially lowered window, a choice about whether to consent. Understanding where the lines are drawn can shape those moments in profound ways. So, stay informed, study your state's firearm regulations, keep documentation current, approach encounters with composure, and remember that rights preserved in theory must be exercised wisely in practice. The Supreme Court has spoken clearly on this issue. Legal gun ownership alone does not justify a warrantless vehicle search. That principle now stands as binding precedent. What happens in the field will continue to depend on facts, context, and conduct, but the constitutional foundation has been reinforced. And in a landscape where small misunderstandings can carry enormous consequences, that reinforcement matters more than most people realize.